final panel in the We Reach Biomedical Entrepreneurship Bootcamp. This one is focused on legal issues and intellectual property. And I'm Terry Butler. I'm with the We Reach Biomedical Entrepreneurship Center, and my role is outreach and partnerships. And we have 3 panel members here today, and I will have them introduce themselves.
Sure. My name is David Sheldon. I'm a patent attorney here at Christensen O'Connor Johnson Kindness in downtown Seattle. My background is in computer science, so most of the patent drafting and prosecution that I work on is somehow related to software. But a lot of the stuff that I've worked on also, has some sort of mechanical component or is related to some sort of biomedical device or treatment technique or diagnostic technique. So have some relevant background in this type of technology.
Great, thank you.
Hi, my name's Alex Madowski. I'm an attorney with the Tuttle Law Firm and also an angel investor, and been working with startups for a long, long time. And our firm is a firm of 65 lawyers in downtown Seattle. We do all sorts of business law type of work. I'm the lead for the Emerging Companies Group and for the intellectual property. I'm co-lead there. And one of the things that I've really enjoyed over the last few years is that I was one of the persons who set up something called Seattle Angel Fund, which is now called Sea Change Fund. And over the last 5 years, they have raised committed capital of about $20 million and invested about $15 million of that so far. And we're in the process of investing the rest of what we have and raising another fund probably in April. So fun stuff.
Good to know.
Hi, I'm Jennifer Fan. I'm an assistant professor of law at the University of Washington School of Law, where I teach the Entrepreneurial Law Clinic and venture capital deals and business organizations. I practiced for many years, probably very different from most academics, but I practiced for about 10 years before joining academia. My background is more in corporate securities. I, like Alex, also worked extensively with startups and also just throughout the whole life cycle of a company. So I represented high-tech companies, biotech companies, and the like at law firms here in Seattle, New York City, and also Silicon Valley. And in the clinic, which I run, the Entrepreneurial Law Clinic, we provide free legal services to microenterprises, high-tech ventures, nonprofits, and social ventures. And we also have helped CoMotion when they've had startups.
Okay, so we'll dig right in. At what point in the development process do you all recommend someone pursue patent rights? That's always a question with technical teams. So whoever would like to respond first. Actually, Jennifer, maybe we should have you respond because you see a lot of our early stage teams.
Well, I think David might be a better person to answer that
well,
one.
Push it up onto David.
because he's a patent
fine.
person, but I think this also goes to like what the relationship with your attorney is like, and so they can really be a partner, because I know a lot of people see lawyers as roadblocks, but in the transactional practice, I think you really have to partner with your clients, figure out what they want, what stage they are in their development, and David will know the specifics of when exactly they're ready to move forward with a patent. But oftentimes we have clients who come to us that think they have what is something patentable but is not, or perhaps it is something that is very narrow that it might not be worth pursuing a patent for. So we try to walk them through that process and what it looks like, how much it will cost, and the like.
Okay. Well, I'm interested in Alex's answer to this because he has a higher level view of it. So, like I said, I'm a patent. I'm a patent attorney. So by the time people are coming to me, they probably already have an idea that they want a patent. But that said, I think that there's a couple things to think about, right? There is what patents do other people have, and then what can I protect? You probably want to be thinking about what patents other people have and doing some kind of freedom to operate searching like as soon as possible.
And what does freedom to operate mean?
Just making sure that there aren't other patents out there held by other people that would stop you from doing what you want to do. If there are patents out there, then you can make the decision, okay, I'm going to do something else, or I'm going to work with the patent attorney to figure out how I can design my product around what's already out there, and maintain your freedom to operate. Then the other, of course, the flip side is getting your own patent. Getting a patent doesn't mean you get to make your product. That's what freedom to operate means. But it would mean that you can stop other people from making your product. So, searching for whether there is other prior art out there that would stop you from patenting it is important. I think the time to do it is definitely before you make anything public. That's when people come to me, that's the problem that I see. Like, they will have already presented their invention publicly, and that presentation, number one, it starts the clock on a year deadline to file in the US, and it also eliminates your ability to file in most foreign countries, in foreign countries you usually have to have a patent on file before there's any public disclosure in order to get a patent. So I guess that's the key takeaway, my answer for this question, is that make sure you have your patent strategy figured out before you make any public disclosures.
Yeah, I guess the thing I would add, back in 1982, when I started at Texas Instruments, I used to play poker with the guys from the Central Research Labs, and they wouldn't tell, at the beginning of the game, before people started drinking beer, they wouldn't tell you what they were working on. But after a few beers, their colleagues would be asking them, how things were going. And pretty soon, we would find out what they were working on. And I remember distinctly from one of the nights, the guy said he was working on bubble memory, which had to do with using molecules essentially to store data and things like that. And certainly that maybe they could obtain a patent on that because it was so far advanced over what other people were doing. But one of the questions was, okay, maybe you can get a patent, maybe you could protect that patent, but does anybody want it? And so the guys I played poker with said basically they didn't care whether anybody wanted it as long as they were paid to play. So they were having a lot of fun. But, I guess one of the things you want to think about is, does anybody want this thing that you want to build? You can go and do searches, and you can find sort of holes, gaps where maybe you could obtain a patent. But one of the nice things about the provisional patent is you can file a provisional and then go check the marketplace and see if there's any market, any demand for the thing that you want to protect. And so yeah, my analysis is really essentially the same as yours in terms of freedom to practice, and then can I practice it, and then can I obtain a monopoly and stop others? So probably most of you, I don't know if you've all taken classes in entrepreneurship or not, but one of the things you want to think about is what is your protectable competitive advantage over the others that you're going to be competing with out in the marketplace. And so patents are definitely a very powerful tool to use in terms of a protectable competitive advantage. Sometimes if the answer is I can't get a patent, that's not necessarily a bad thing. And so just because the answer might be no, or it might be that the subject matter is not patentable subject matter, that doesn't necessarily mean that you shouldn't build a business around it. Very often, a lot of my clients are software companies, and a lot of times nowadays they put the intelligence onto a network. They don't distribute the secret sauce around the world. They hide it and protect it, sort of like the formula to Coca-Cola. And that franchise has lasted over 100 years. So that's something to think about with your attorney and your co-founders is, does it need to be patented? Defending a patent, going after somebody who's infringed the patent is very expensive. So just because something's not necessarily patentable doesn't mean you can't build a great business around it. And just sorry to be so long, I won't monopolize on the other questions. Years ago, I had a client who started a company called housevalues.com, and the idea wasn't protectable in any way. There was nothing protectable about it whatsoever. It's just that the other two companies that were out there in the real estate online real estate space that had similar business models couldn't afford to switch once they saw our business model. They would have cannibalized their businesses. And so the plan was start the business, execute well, and run like hell. And that company ended up 5 years later having an IPO on the NASDAQ and was a huge success. Nothing patentable.
Yeah, great lessons. What all of them were saying harkens back to our first panel on customer discovery and searching for competitors, basically market research. You don't want to go down the path of getting an expensive patent if you really don't have a market for it. And so how much might it cost to get a patent, Dave?
Depends on how complicated the technology is. Normally, we quote, the low end is usually around $8,000, the high end like 12 to 15. That's for the initial drafting, preparation, and filing of the application. Then 90% of applications get rejected by the patent office, so you have to go back and forth with responses to the patent office. We usually say to budget for about 3. Each one of those, I'd say, assume you're going to pay about $3,500 for each one of those rounds. And then there's issue fee and maintenance fees after that.
And that's just in one country.
That's just in one country, yes. That's just in the United States. If you want to file, in Canada is probably about the same, except you have yearly maintenance fees. China, possibly about the same. Other countries like Japan and Europe tend to be much more expensive in terms of filing fees and translation costs and things like that. So I would say like double those costs if you were going to file in Europe.
So 20 to 100 grand. So you better be serious about your idea if it needs intellectual property. And actually a lot of health, like medical devices typically do need some kind of intellectual property protection. Therapeutics, biologics definitely do. So you can see where you either need to get serious or go make pies or something.
Can I add something? So what I've seen some clients do too in order to save money because they're worried about the cost is they try to draft it themselves first. That never ends well, so I would suggest not doing that. They're very smart in their particular fields, but I think for patent drafting, there's a very particular way of drafting it that someone without training in it is not going to know, and also to be sure that the person who you're hiring for the particular project has expertise in that technical area.
So you might not want someone who works in the food space, for instance, or consumer products to do software or to do medical device.
Yeah, probably not. I think about this a lot. Like at my firm, we have people from widely different technology backgrounds, and like I said, my background is software. I feel comfortable branching out into mechanical stuff, like simple mechanical stuff. So there's a little bit of overlap there. I often think that lots of people could do a lot of the software stuff that I work on. but the person in the office, the other side of me, works on chemistry and life sciences, and I have a hard time understanding the subject lines of the things that they work on, let alone the actual inventions. So yeah, there's definitely a point where you need somebody with specific expertise.
Specialty.
Yeah.
So while we're on it, on patent costs and such, what about provisionals? So you want it to be, be pretty official. How much would it cost to throw in a provisional,
Sure.
for instance, before you start
So-
running off to conferences and talking about things?
Sure. So a provisional application, just to explain what it is, it's basically a placeholder application that saves your filing date for 1 year. At any time during that year, you can file a non-provisional application, which is like a real patent application that gets examined and everything. The provisional application, it stays secret, and if you don't file a non-provisional application that claims the benefit to it, it just goes away. One strategy that people use is they will file a provisional application that is not as complete as their non-provisional application. So costs can be kept low. That might be something that they might draft themselves, or they might, if they're going to have a PowerPoint presentation, they're going to present at a conference or something, they might file that PowerPoint presentation as a provisional application. There are upsides and downsides. The upside is it's cheap. The downside is you get what you pay for. So depending on who you ask, if you ask, say, a patent litigator, they would say never ever do that, because what's going to happen is when it gets to litigation, they're going to compare the non-provisional application to the provisional application, and any differences in between those two, they're going to say that's new matter that wasn't disclosed fully in the provisional application, so you don't get the benefit of that priority date. That can be fatal if, say, you filed that provisional application almost a year after your disclosure and you really need the benefit of that priority date, or if there was prior art that came up by a third party in between the provisional and the non-provisional. So if you think it's going to be vital that you get the benefit of that provisional filing date, you don't want there to be any differences between the two. So the cost can be very low if you draft most of it yourself, but any differences between that and the non-provisional could lead to problems down the road.
Great, thank you. That's really helpful. So what about patent searching? What kinds of tools would you guys recommend for people at different stages in terms of their patent searching?
Well, the U.S. Patent Office has a great searching index. You can go through and get a sense for what the patents in the space have been filed in the past. Unfortunately, new patents aren't made public, new patent applications, and so whoever's filed one, I think, 18 months? You don't know what's been filed in the last 18 months. It's not made public. That's one of the nice things about the provisionals, too. I've had clients who file really sloppy, crummy provisionals, but they go out and do their market research and tell everybody, oh yeah, we filed a provisional, so that's already protected, and a lot of times that's good enough to keep other people from copying what they're doing. Now it's a gamble, doing that, as David points out, but then there are consultants out there that perform searches. And they're quite excellent, and they tend to be, pretty reasonable in price. So definitely, if you've gone and done the searches yourself, if you're really good at that, I've had clients who come in who are just amazing and have done fantastic searches. But we don't tend to do searches for the clients. We ask them if they've done it. We kind of ask them a lot of questions about their searches and what they've done and who's out there. We might go out on the web and do a little bit of searching just to make ourselves feel comfortable about things. But normally we'll send them out to a consultant, but I'd be interested in hearing what David has to say.
Yeah, we do a little bit of both. Like we have, there's one client in particular where we've worked on a group of inventions that are all pretty related and all like very cutting edge. So I feel like I understand how to search for that technology better. I'm more comfortable with that than I would feel with explaining it to a search firm so that they would actually conduct a good search. But that case aside, most of the time, if we're going to do a patentability search, we would farm it out to Cardinal IP or some other firm that does that, because their searches are better than ours and very quick. So like we usually pay in the neighborhood of like $800 for a patentability search. And so that's patentability, right? So that's just, is there prior art out there that teaches some of the things that you do? Costs for other types of searching are usually a lot higher. Like if you want a freedom to operate search done by one of those firms, they charge more. Or if you want an invalidity search, they charge more.
And also here on campus, they have, I think it's called the Patent Resource Center. So they help with librarians who kind of can help walk you through how to do a patent search, but they don't do the patent search for you.
And as a first pass, Google Patents is really easy to use, so you guys can learn a lot by using Google Patents.
Yeah. Oh, one thing I would say, and this is something I see people stumble over, is that when you are patent search, if you're trying to figure out whether your invention is patentable, you would do a search on Google search or on Google Patents to try to find some patents that are relevant. What you need to look at is everything that's in the patent. Like look at the drawings, look at the entire specification, and see what they teach. Sometimes people will just look at the claims and they'll say, oh, this isn't claiming what my invention is, so I can file a patent on it. That's not the way to do it. Those patents are prior art for everything, for its entire content. So that's just one pitfall to try to avoid.
And then one of the issues is with regard to whether something's patentable subject matter, you're not probably really going to get an answer, that negative response that you need. So that's something that unfortunately you just would have to learn about what's patentable subject matter. And for example, in the area of software, that can be very tricky to figure out without speaking to a lawyer. We got a question in the back, Terry.
Oh, we'll take questions at the end, if you don't mind. Thanks, Chris. So for those of you who are at UDub, maybe Jennifer can help us with this one. Does the UDub have patent rights to inventions?
Well, it depends on if you're using UDub resources or not. So in particular, I found with the sciences, because you're usually using lab facilities on campus, then the UDub will have an IP interest in what you're doing. And so you need to go through CoMotion to talk to them to sort of determine whether or not the IP rights are going to belong to CoMotion or it belongs with whoever the inventor is. Sometimes if we have students in the audience here, I'll have to say that that question comes up a lot, particularly if they're a graduate student who might be working on a similar thing to what their advisor is working on, and so then having to speak to the advisor, determining like where that line kind of falls, and again whether or not they're using the wet labs or what have you. But if it's just a regular class that you're taking as a student and you develop the idea within the class context, then that will not belong to the university. And I know that CoMotion has specific policies about kind of you'll license the technology from CoMotion if you end up having a spin-off from the university.
And so that goes for those of you from other institutions as well. Just check with your technology transfer office on what their policies are.
But there's a bright side to that, and that is that possibly the university will pay the patent costs. They always hire great lawyers to do that patent work, and so that might be a really good thing.
Yeah, and I know for some of our courses, they do have the inventions go through the technology transfer office for just that reason, as if there is intellectual property, the student doesn't have $3,000 to $20,000+ to to protect it, but CoMotion, if they see value there, then they can protect it while the student can continue to work on it throughout their undergrad or grad years.
Yeah, can I add one thing though? So they typically will do the provisional patent application. And then, for example, like my clinic helps with doing kind of a patent landscape analysis light. And then they'll determine whether or not they'll take it on as a non-provisional patent application. But usually at that point, for most of them, they'll be expected to cover the costs on their own, just given the high costs, and that they'll be in the hands of attorneys, such as David's firm, where they can take on the work from there. But I think just given the size of various of the legal team, they might not be able to do the full-blown non-provisional.
Whole thing, but it buys you time, gets you in the hands of some experts, and buys time until you figure out whether it's really worth pursuing.
And they used to have a bigger budget for that and did a lot more of the filings, and now they've been scaling that back. But, the time may come, let's say we have a change of administrations and better funding for some of these things, then it's possible that the university might be more aggressive about filing patents again in the future. So it may, kind of waxes and wanes.
So patents aren't the only kind of intellectual property. What about other kinds of intellectual property, and when should teams worry about those or take advantage of those?
Well, there's a number of other ones. Earlier Alex had mentioned trade secrets. So trade secret is when, it's like the Coca-Cola formula, Kentucky Fried Chicken recipe, what have you. So there's some inherent economic value in the intellectual property. So, for example, could be like a customer list or what have you, could also count as a trade secret. And the thing is, you would have to take reasonable measures to keep the information secret, such as having people sign NDAs, only have a limited number of people being able to access the information, and so forth. And it's probably the cheapest form of intellectual property protection, and it's indefinite. But of course, on the flip side of that, people can reverse engineer something. So if someone somehow figured out the Coca-Cola formula, Coca-Cola is out of luck, but it seems to have been doing well for the past 100 years or so. So.
And that's a place where trademark comes in, right? So somebody figures out the formula and they say, yeah, we're not Coke, but we've got they can't say Coke, right? We got something that's really, really good cola, and you're going to love the taste of it. You're already kind of used to it, but they can't use the trademark. So without being able to use that branding, there's no way for them to tell the world that they've figured out the recipe for Coca-Cola, right? So.
And the trademarks also last indefinitely, isn't that right?
Well,
Or they
in a
have to
sense,
maintain
yeah.
them.
I mean, you can renew, you just renew them in essence, to put it simply, and you have to pay certain fees. Initially every 5 years, and then it goes to every 10 years, and you keep those babies alive for as long as possible if they're serving your purpose. And it can make it very difficult for somebody to come in and challenge you if they don't have the brand and you have a powerful brand that people really believe in. Copyrights is another way to go. Copyrights protect the form of expression. So essentially you can protect a book, what I've written in a book. You can protect music on a sheet of music, and then the performance, that's another form of expression. You can copyright that. So, I think somebody told me that the McDonald's fun meal was protected by design patents, copyrights, trademark. I think there was also the non-functional aspects of the box, I think, were protected as trademark. So sometimes you can really pile on with the protections, and then your lawyers get to choose from the various remedies available when they go after somebody.
Yeah, so one thing that Alex mentioned was design patents. We didn't really talk about that in any detail before. A design patent is different. Usually when you think of a patent, you think of a utility patent, which would protect, like a process or the functional aspects of a device. A design patent is going to protect the ornamental features of something. So the non-functional aspects, they tend to be much less expensive than utility patents because all you really file is a bunch of drawings. They don't have quite the scope of protection, but if there are ornamental features for your invention, it can be a low-cost way to get protection for them.
And the damages are calculated in a slightly different manner. I think now with regard to that Apple versus Samsung, what was that, like a $5 billion judgment? Partially because of the way that the statute's written. Now there's been some cases that I think pull back some of the additional benefit in terms of the damages that you're able to obtain. Maybe David could explain that.
Probably not. So I don't. When we get into litigation and damages, my knowledge starts to tail
Far
off.
down the pipeline for our startups.
But everyone
Hopefully.
started saying after that decision, oh man, let's just go get a design patent and we'll really knock them out of the park. And then the circuit court started looking at that and saying, you know what, we've been wanting to look at this and write opinions on this for a while. We think people have been misconstruing the damage provisions with regard to design patents. So not being a litigator either, I'm not sure exactly where that stands now, but just to say, getting different types of protection and layering them on can be a really good idea if you can afford it. If you can't afford it, one of the things to talk to a lawyer about is, what can I get away with here to start my business without spending so much money? And that's a tough one.
That is, yeah, give and take for sure. Another basic thing we didn't cover, one second, is how long does a patent last?
So a utility patent lasts 20 years from the filing date. So all the time that you spend prosecuting it, trying to get it allowed, like unless there's some delay that happens at the patent office that's outside of their guidelines, you don't get past that 20 years.
So if it takes them 3 years to look at it, that's part of your clock ticking?
Right.
Okay, great.
There's a lot of complicated rules about if they have delay beyond this specific set of regulations, you can get some time tacked on to the end. But to a first approximation, it's 20 years.
Okay. And Jennifer?
But for design patents, isn't it short? It's 20, 12 years or something?
I forget, 14
14?
sounds right.
Yeah, so, yeah.
I didn't know
Yeah.
that.
But what I was going to mention for copyright is a lot of people, as soon as Alex was saying, it's an original work of authorship. So, and as soon as it's put down in a tangible medium, but what that means is, if I wrote something down here and it's copyrighted, right? I mean, I have copyright protection. However, if you want damages, then you need to actually file it with the U.S. Copyright Office. And that actually isn't that expensive to do.
Yeah, if you want statutory damages.
Yeah.
Yeah.
I didn't know that either.
Yeah,
Learn something new all
so
the
lawyers send out these threatening letters citing statutory damages, and there's not even a copyright filed with the Copyright Office, and that's a problem. I think the way it works is that if you can prove actual damages, I think those might be available, though. But the statutory damages are nice because the amounts in the statute are really scary.
Let's see, we did cover copyright versus patent. And so software, we mentioned software, and software on patents or other approaches to protecting software are just flat out not protecting it. What types of strategies have you guys seen, and what do you recommend? Because even some of our medical devices and such will have software components, so.
It might be good for David to talk a little bit about the Alice
Sure.
decision.
Yeah, so one of the big topics in this area is whether or not software is the kind of thing that you can get a patent on. There was a decision back in 2014, I think it was, that people refer to as Alice, which in which the Supreme Court set out these new rules for how we were going to analyze whether a application directed to, or analyze whether an application is directed to an abstract idea and is therefore not patent eligible, or is not directed to an abstract idea and is therefore patent eligible, or the type of thing that you can patent. So that decision had a big effect in the Federal Circuit for the next couple of years. Next couple of years, the Federal Circuit basically struck down every software-related patent that came in front of it. It was not a super fun time for me and other people who do software patents like I do. But eventually, there were a few cases that swung the other way. Not a lot of good things I could point to that came out of the Trump administration, but he did name a new director of the Patent Office who he was a litigator who worked on both the plaintiff and defense side of various patent issues, and he has taken a lot of steps within the PTO to try to clarify the rules with regard to subject matter eligibility. There has been a lot of internal training and memos that they've issued to try to clarify internal policy, along with, in view of all of the cases that have been issued by the Federal Circuit. The effect of all that guidance has been to make it a bit easier to get software patents than it was before his tenure. In a nutshell, the way I like to summarize it is that if your software has some kind of technical effect, or if your innovation in software has some kind of technical benefit, technical improvement, then it's probably going to be the kind of thing that is not seen as an abstract idea, and you're going to be able to get a patent on it. If you are just if the innovation isn't on the technical side, so if you're not making the computer do something faster, do something cheaper, do something that maybe it couldn't do before, if the innovation is in something else, like we have a technique that's generating better house prices, or we have a technique that's making it possible to buy or sell things on the internet, those kinds of things are going to be seen as fundamental economic practices, or merely math, or an idea in itself, and those are going to be things that are found to be abstract ideas and not patent eligible. So it's kind of a long-winded answer. There's been a lot of movement in this area in the past 5 years or so. It's the kind of thing where you will go to a patent attorney and you will go to them and say, "Is this thing patent eligible?" And they're going to say, "I don't know." And we'll have to submit it to the patent office, and the patent office is going to say, "I don't know." And it's been really tough to give good advice in this area. There's a lot of there's certain things where you can you can have a pretty good feeling about, this is gonna, this is on like a specific device, and it's making the specific device do something way better, or we're improving the way a computer works in that we have a new caching scheme that saves 30% of our network bandwidth or something. If you can point to a provable technical benefit like that, then I feel comfortable saying it's the kind of thing you can get a patent on. Anything short of that, it's real fuzzy right now.
And what about if you have software that interacts with some hardware? Is there a way to think about that?
So if the hardware is novel, then you're probably going to want to direct claims to the hardware. If the software is interacting with a specific piece of hardware, that can help with regard to patent eligibility. Sometimes it has to be really specific. Like there was a case out there that you probably heard of. It had to do with it was software for a helmet that you would wear in a fighter jet, and it had it was about displaying a heads-up display and making sure that the orientation of the display was proper with regard to which way the pilot's head was oriented and which way the aircraft was moving. So there are all of these like inertial sensors that would feed into how this display was generated. And originally it was found patent ineligible as just merely being, math, which, to a certain extent it is math, but it's math that is inextricably bound with this very specific hardware system. I believe eventually they were able to convince a court that, yes, that is specific enough hardware that it was patent eligible, but it was a fight.
Another thing to think about is what are the rules overseas? There might be, for example, in China, where what percentage of our manufactured goods are made. You may want to look at what the eligibility is in China, and if you're able to do that, and the answer is yes, it is patent eligible, and you're able to get a patent, that may also boost your opportunity to obtain financing.
So one more topic area I wanted to cover that it looks like we have time for, and a question that frequently comes up is, when should people set up a company and what type of structure? Would you recommend what, where, when?
I think it depends on a couple of different factors, like at what stage of development is your intellectual property at, because eventually you're going to want it to house it in an entity for liability reasons, because part of the reason you form an entity is so that you no longer have unlimited liability, because otherwise if you're working by yourself, you're considered what's called a sole proprietor, or if you're partnered with someone else with the intention of going into a business for profit, then you're a general partnership, and again that has unlimited liability attached to it. And particularly if you're working on something, it's not like a board game or something like that, then you'll want to have an entity around it. Another consideration is funding. So, what kind of funding do you want to go after also has implications for what type of entity you choose. So, for example, if you're going after venture capital funding, then you'll want to form as a C Corp for tax and other reasons. You might think, well, what do you mean tax? Because that's, double tax, and you're taxed once at the company level, once at the shareholder level. But there, it's because there's specific tax. There's a specific tax section called Section 1202, where if you have stock in a company for a certain amount of time, you can take up to, I think it was like $10 million, kind of tax-free for your stock. So that's a pretty big advantage.
So big that pretty much, overnight, people switched from other forms of entities for startups to C corporations, because they said that's all the angel investors or the VCs, want to invest in anymore. So no, when it came to you 10 years ago and we talked about a startup, we talked about an LLC, we talked about an S Corp. I don't care about any of that anymore. Nobody cares about that. But at universities, people still do care about LLCs. A lot of times if it's just an R&D type of entity, you're going to be submitting grant applications. You may very well want to go ahead and keep it as a simple LLC. You don't have to have annual meetings. You don't have to spend a lot of money. But on the other hand, as I tell people, LLCs can get real complicated too, and the accounting can get really complicated, and revising a 100-page operating agreement for an LLC can get very costly. So it's not that LLCs are always inexpensive or simple. They can be incredibly complex, but they can be really, really simple. And part of my answer typically with regard to when to set up an entity, it's any time that you're working with somebody else and they're working for sweat equity, or they're contributing intellectual property, or they're contributing money, you better get things on paper, get people to sign things. That way you avoid any kind of disagreements.
Yeah, the other thing I want to add on the LLC front is, it's right that a lot of times at the university level, people do form an LLC first. And so there is a conversion statute that we have here in Washington State, which makes it fairly easy to convert from an LLC to a C Corp, for example. But again, that costs money. It has to be done in the right way. So it costs a couple $1,000s that a company might want to not want to spend. But again, if it's in the R&D phase or what have you, it might be okay because you don't know if it's actually going to come to fruition, and you might say like, oh, we have still a couple of years runway, so maybe we just hold it as an LLC so we can get that grant money in. We're not looking for, VC funding or angel funding or what have you. The other thing is too, here in Washington State, there you can have oral agreements, right, for when you have LLCs. So under the Washington LLC Act, which was revised back in 2016, they were trying to make it more, entrepreneur friendly by doing that. But that comes with some cost because operating agreements can be fairly complex. Once you get into it and are very customized and so forth. But you really have to get things in writing, which is because of the fact that you otherwise might have an oral agreement that you might be subject to, that maybe you didn't know you were entering into an oral agreement, but then you have to then go into litigation.
And the statute has certain presumptions and defaults so that if you don't write it down differently, for example, the presumption in the statute is that you have, if there are 3 people, they each own 1/3. If that's not what your intention was, you better get that down in writing.
Which brings me to, how do you decide how to split up the ownership of a company at the beginning before you know really who's going to do what?
It's one of the most intractable problems in my practice, okay?
You encounter it fairly early, unfortunately.
I've got a client right now who's going through this, and it was clear that she was going to be the CEO, and she was going to own a majority, at least for the near future. And then they found this brilliant person to come in as a CTO. And so now the third person who was supposed to get, something like 40% is saying, wait a minute, we bring in this CTO, I'm down to 20%. That just shows you don't respect me. Things like that. And so things start getting pretty personal. And the arguments get personal. You don't respect me, et cetera, et cetera. There's a book, let's see, was it the the Innovator's Dilemma or Entrepreneur's Dilemma?
Innovator's Dilemma.
And he's got a chapter on how you split up equity. One of the ways that people talk about splitting up equity is to start building matrices, a matrix of the different types of people you're going to need on your team. There are sort of customary within Seattle percentages that different people in an organization get. I think that in general, the thing that most scientists and startup people who've never been involved in a startup before kind of don't know that you should know is that you can fix a lot of things with the concept of vesting, okay? So you may award a certain amount of equity to someone, but if they end up not performing, they won't get all of the percentage that was allocated to them. And then the tough thing is just to determine who's the decider about whether or not someone is measuring up. I think Paul Allen wrote about his discussion about this topic with Bill Gates. I think originally they started out as 50-50 owners of Microsoft, and then Bill had a talk with Paul. And Paul had to give up some of his percentage because Bill basically told him, you're not carrying your weight. It's not fair to me what I'm having to do here and the value that I'm contributing, so you're going to have to agree to take less. Now, if you've seen Paul Allen's yacht and the properties he has and things like that, you think, good decision, Paul. But it can be quite painful. I had a client, we started up a pharmaceutical discovery sort of company years ago, and he owned all of it, and he had a professor from Stanford who was a Nobel laureate who came in initially for 3%, but then when he found a person with money to put into the company, suddenly he wanted a much higher percentage, and the money guy, who was his friend, said, I'm not coming in unless you give him 30%. And so then along with that, they said, you've got to use our attorneys. So I lost my client at that point. And next I heard he was below 20% in ownership of the company. So, you know, these discussions get pretty heated, and everyone's got to decide sort of as the pie gets bigger, that percentage that I am going to have if I perform, is that good enough to compensate me for the work I'm going to do? And you have to think about it in terms of, this is my investment. It's like, if I put that into money terms, this work, like I could go to Google would pay me $450,000 a year for the next 10 years, you know, and I'll get raises. What does that look like versus the 10 years I'm going to put into this company? And what's the probable sale price of a company like this? And what are our odds of success? And you do the calculus, and then you say, yeah, I'll do it, or no, I'm going to go to Google.
Yeah, I mean, again, like I agree with you on all the points you made. I would say, though, that I oftentimes counsel our clients not to talk about it in terms of percentages, because sometimes it can come back and they'll say, well, the percentage as of when. So then once the kind of pie is divided among however many co-founders they are, then we actually talk about numbers, because that, you know, that's what they should get at the end, is like the number, not that they're promised to have 3% of the company indefinitely, you know, into the future, which is how some people interpret it as. Because what some entrepreneurs don't get is eventually their percentage of the ownership, you know, it's going to get diluted as you have investors come on board and so forth. And in some of these unicorn companies, these private companies valued at $1 billion or more, something that interesting that's happened, and Alex, maybe you can speak more about this in your practice, is that, you know, there's now, like, in addition to the sort of vesting arrangements that you mentioned to kind of, that incentivize, first of all, the folks to stay around, but secondly, to get them to do what they're supposed to do. They also have different voting rights. So I'm sure all of you have heard of, like, the WeWork debacle, but there, you know, Adam Newman, part of the reason he was able to walk away with $1 billion is because he had significant voting rights. So for every 1 share of common stock that he held, he got, I forget what it was, but it was something very high, like a couple of hundred votes per 1 share that he held, because that he had specified a certain class of common stock for himself. And so you'll see this in some of the bigger companies. It's basically what you're able to negotiate as well. But at the end of the day, it's all about sort of, you know, the economics and control that you're going to have in the company long term too, because what you're looking at it from a lawyer's perspective is, what kind of votes am I going to need, you know, when the next round of financing comes, or what the company is going to need. And you determine that by having, you know, either like a majority or 2/3, whatever it says in the various documents, in order to get that next round of funding in. And you're going to have to keep pretty tight control over that.
Yeah, another thing that happens is when the VCs come in, or sophisticated angels, a lot of times they'll look at the cap table and they say, nah, this is wrong. We don't like it. Yeah, it says here that you own 10% of the stock. You're going to have to revest in, let's say, 60% of that. So if you want the money, you may have to agree that your ownership of the company just fell 40%, dependent upon your continuing with the company for the next 3 years in order for you to keep that percentage that you thought you already owned. So, and then, you know, everything's subject to dilution. So all of these things change over time, and different players are valued differently at different times in the life cycle of a company. So I heard in fact, it was here at the Boeing Auditorium, I heard somebody who was a successful entrepreneur say that lots of times they bring in people and their stock's going to vest over time, but he knew that, for example, a VP of marketing wasn't likely to last the 4 years anyway. So as soon as that person had trouble, he would just kick them to the curb and they would never get all that stock anyway. I thought that probably wasn't a smart thing to say in front of a crowd of 300 people. But there's got to be somebody who makes the hard decision about whether that person who's earning stock for sweat equity really deserves to continue to be vesting in their stock. Usually, I would say that 70% of CEOs don't have what it takes to make that decision to call the teammate on it, but they really need to, because it's a cancer on the organization. The other people in the organization, it hurts their morale, and they say, whoa, Charlie's vesting in his stock, and he doesn't even come in and do the work he's supposed to be doing, and we're working like crazy for our percentage. Something needs to happen, or why the heck am I working so hard? So somebody has to have that talk with Charlie and tell him, Charlie, you're a great guy, we all love you, but either you're going to have to start performing or you've got to go, or we're going to renegotiate the deal, just like Bill did with Paul.
So I don't have a ton to add, but I do want to add one thing from the patent perspective. When the inventors of a patent both completely own the patent, like if there's two inventors, each of them has an undivided share in the patent. So from my perspective, I don't know too much about what type of business entity you should set up. What I do know is that you should assign that patent to the business entity as soon as possible, because if you end up in one of these situations where you haven't assigned the patent and one person's pulling their weight and one person isn't, you don't have any leverage with regard using the patent. They could go off on their own, and if it's not assigned, they could still use the patent or use the patented technology. So you want to be having the fight over ownership over the company and not over the patent, because the patent could just go away and be worthless if that's what you're fighting over.
Wow, that's good advice. Now, the only other thing I would say about splitting ownership, too, is early on you don't even know what's what, so you should be somewhat concerned about it, because you can see from these stories where it will lead. But on the other hand, you may well have 20 or 50 or 70% of nothing. So don't worry too much about it. And when investors come in, they are pretty heavy-handed in terms of getting you set up sensibly from their point of view. So be aware that there's likely to be some renegotiation on percent ownership in any case at that point. All right, let's take questions.
Following on from your last comment there, David, great one. Provisionals are not assignable, correct?
That is not correct.
It is not?
You could assign a provisional as well.
Provisional?
Yes.
Okay.
In fact, for foreign, like if you want to file a PCT application, which is an international placeholder application, you need to have assigned the right to claim priority to the provisional application. So there would need to be an assignment in place if the company is going to be the applicant in the PCT.
Let me get Chris.
Yeah, so this goes back to the prior art question that you mentioned. What are other potential sources of prior art other than perhaps patents on Google?
So prior art could be any printed publication, public use, sale of the patented item. So yeah, it could be anything. Could be mostly what we would see. We see a lot of patents, pre-grant publications of patents, academic papers. We see a lot of academic papers But it could be anything. Product brochure.
Yeah, I've heard of people's patents being invalidated because litigators went digging around and found a paper published in the Ukraine or something. So some language you may not typically be reading in your literature reviews.
Yeah.
And so, yeah, prior art can be in any way, shape, or form. It's
Yeah, and these
risky.
these are the things that I've run across that get found by the patent office. If you're in litigation, litigator is going to find anything they possibly can. They're going to, look at, old VHS tapes that might show like an example of the art. Anything they can possibly find. Yeah.
On the provisional front, I have a weird question. Suppose your provisional is expiring at the end of the month. Can you refile a provision on the same matter and extend the filing date?
So extending the filing date on provisionals, that's what the question is.
So it gets a little complicated. The simple, incomplete answer is yes, you could refile a provisional and you get a year from that date instead. It doesn't extend it. Like, you don't get the filing date of the original provisional application. You only get the new filing date, a year from that new filing date. So it would be like the first provisional never happened. So that is true in the US. If you want to file a PCT application, so an international application, you can't do that. You have to have, you can't have overlapping provisionals. You could wait a year and a day and file, but you need to have a break in between the two, and then you could claim priority to that provisional.
And David, you have a question?
I want to get back to the assignment of a patent to a business entity. What if you, how often have you seen them, an inventor license the patent to the business entity versus assignment?
Assignment of a patent versus licensing it to a business entity.
Wow. Investors really hate that. Licenses can be terminated for lots of different reasons. So it's pretty typical that investors will say, nah, we're not going to invest in that because of that reason.
Well, but I mean, Jennifer, what about CoMotion, right? Because that's basically CoMotion's business model, isn't it? Like, they own the patent, but they license it out.
I think it's a little different, though, with university-related spin-outs. So I think that everyone kind of knows how that works. And, I mean, what have you seen in your...
The university doesn't want to practice the patent.
Right, so...
in terms of like doing a product or something like that. So, yeah, I think that's just viewed very differently.
Okay, well, I think we should wrap up here and thank our panel.